historical foundations for Western law generally, and examining some of the big themes that recur over and over throughout the Western legal tradition, and looking at some of the innovative or critical moments during which these themes first arose. Looking, for example, at Sophocles' play Antigone, and the idea of a conflict between higher and lower law, or the trial and death of Socrates, and the idea of law being directed toward justice, whatever that is. Looking at the writings of Aristotle and the relationship between justice and reason. Looking at the law of Moses and of St. Paul, and their claims about law being grounded in the just claims of a personal God. And then finally looking at Aquinas and the tradition which he perfected and inaugurated, in some ways carried on by later jurists, including recent jurists such as Martin Luther King Jr. This idea that human law is or can be derived from natural law, the law of reason, and principles of reason which are accessible to human practical reason and are universal. Today we begin to shift, and we're going to begin looking more particularly at the American legal tradition. We begin today not actually consulting an American jurist, but an English one. And the reason, of course, is that the American tradition begins with the English common law. In this second part of the course, we're going to talk about different tensions in the common law tradition. American law today is now many different things, and so the study of the particular norms and institutions of American law is going to take us for the rest of the semester. But at the time of the American founding, and for a century and a half before that, the law in the United States, what became the United States, the law in British North America, was the common law, the law that was common throughout the British realm. Common law was and is the law that is common to England and her various colonies, former and current, each settled by either the express grant or the toleration of the English crown. Now, as we're going to see, none of the colonies adopted English common law in its entirety. We'll see some important themes, particular doctrines, and even structural doctrines of English common law that the Americans rejected at the time of the American founding. The most famous of these include the doctrine of primogeniture, an English common law doctrine which held that the oldest son inherits the whole estate. And we Americans said, well, that doesn't jive with our understanding of natural law. We're getting rid of that. Equal inheritance in the American legal tradition. We got rid of the English doctrine of coverture, under which when a woman became married, her legal identity was subsumed into the legal identity of her husband. We got rid of forfeiture and abolition as punishment for suicide, and some other more particular legal doctrines. But on the whole, the norms and institutions of English common law are our norms and institutions. The jury trial, from English common law. Private property estates and ownership, English common law. Due process of law, as we'll see, comes from English common law. Pretty much all the rights enumerated in the Bill of Rights, as we'll see in a couple of weeks, come from English common law. So common law is the foundation of American law. Now, briefly, what role or where does common law slot into your legal reasoning and your study of the law? Now, we've already learned how to use logic in law. That is, the tools of critical reasoning mentioned by Aristotle and broken down for us by Aquinas, right? Logic is the tool of doing legal reasoning. You Start with terms, which you clearly define, combine the terms into premises, combine the premises into syllogisms, syllogisms into arguments, and then you can work it the other way around using logic to critique arguments constructed by others. We could, for example, look for an ambiguous or contestable term. What counts as a vehicle in the park? Or what counts as marriage? We could look at an ambiguous or contestable premise. For example, that one is liable for battery when one intentionally causes harmful or offensive contact to another. That's ambiguous. Does that mean that one must intend the contact? Or does it mean that one must have intended harmful contact? Two different things. Or we can spot logical fallacies. For example, that slavery does not violate natural rights because it's natural to the human condition. We exposed that one already, didn't we? So logic is a very, very useful thing in legal reasoning, but logic is not all there is to legal reasoning, as we saw. You can have sound logic and still have an incorrect conclusion if your terms and premises are wrong. That is, if they're inconsistent with reality. That is, if they are untrue. As we learned from Socrates, the point of practical reasoning is to get at practical truth, to get at the correct answer to the question, what is to be done? What should I do? What should we do? So to get to the truth, you have to be logical, but it's not sufficient to be logical. We also need to consult practical wisdom. That was Socrates' claim. In the American tradition, the master is known as the common law mind, and the tradition of practical wisdom is known as the common law, the customary law, the customary norms and institutions that we inherited from England at the time of the founding. Okay, some basic features of common law, which we're going to pull out of the reading that you did for today. First, we're going to start with Blackstone's definition of law. Blackstone is the most important of the common law jurists, in part because his commentaries on the law of England, which were originally lectures which he delivered at Oxford University of Oxford, were first published in 1765. And the first edition arrived on American soil at a time when most American lawyers and statesmen did not have sufficient funds to buy expensive and expansive law libraries. So Blackstone's neat little 4-volume summary of the entire corpus of English law served as essentially law libraries for most American lawyers. Blackstone thus became the most important influence on American law from 1765 all the way through the late 18th and through the 19th and early into the 20th century. He still remains a very important influence when lawyers and jurists, justices in the Supreme Court of the United States, for example, or a state Supreme Court, are trying to figure out the original meaning of a constitutional or statutory term. The best evidence for that meaning is going to be found in Blackstone's commentaries. So Blackstone is a very important figure to know. And he's going to be our guide, primary guide, for the study of the common law. We'll look to some others as well, such as Jim Stoner and Joseph Story. But we're going to begin by evaluating what common law is with reference to Blackstone's definition of law. The definition is on page 230. And we can break this down into its constituent elements. Blackstone does break it down into its elements over the next several pages. He defines what Aquinas called human law. Blackstone calls it municipal law. Municipal, for Blackstone, does not mean simply city ordinances. It means law created by human beings, what Aquinas called human law. Municipal law, he calls a rule of civil conduct prescribed by the supreme power in a state, commanding what is right and prohibiting what is wrong. That's the definition, and let's spend a few minutes unpacking it. The first thing to note, Blackstone says, is that it is a rule. Law is a rule. It must be permanent, uniform, universal. It cannot have application only to a particular person or case. That's a judgment. A judgment is not a law. A judgment and a rule are two different things. A law must be a rule, and so it must be uniform and universal. Also, a law must have binding injunctive force. Citizens must not be at liberty to judge its reasonableness. It is a command. One is bound and obligated to obey it regardless of one's consent or one's own judgment or assessment that it is in fact reasonable. So he says this, it is also called a rule, that is the law, to distinguish it from advice or counsel, which we are at liberty to follow or not as we see proper, and to judge upon the reasonableness or unreasonableness of the thing advised, whereas our obedience to the law depends not upon our approbation, but upon the maker's will. Counsel is only a matter of persuasion. Law is a matter of injunction. Okay, so the first thing to note, Blackstone says, is that law is a rule. So it must be universal in general rather than particular, like a judgment. And it's not like advice, which you're free to disregard. The will of the sovereign obligates you. This idea of a sovereign will is going to be with us over the next couple of weeks. A student of Blackstone who's going to reject quite a lot of what Blackstone's going to tell us today is going to latch on to this idea of sovereign will and turn it into an entire theory of law. Bracket that and set it aside for now. Blackstone wants you to know that law is a rule which obligates and is not merely counsel or advice. Second, of civil conduct. So common law is not natural law. It's like natural law in that both natural law and common law are unwritten law, or consist largely of unwritten law. It is civil law, the law of society. Civil law governs relationships between and among citizens and neighbors who live in a particular society. In this case, England and her colonies. Blackstone says that if we lived unconnected in a state of nature, then we would need only divine law and natural law. But, like Aristotle, Blackstone ridicules the idea that we could ever live alone in a state of nature. We are naturally drawn to live in society, Blackstone thinks, so we need human laws. Natural laws are not sufficient. 3, it must be prescribed. Blackstone's idea that the law must be prescribed is very similar to Aquinas' idea that the law must be promulgated. Prescribed and promulgated are more or less synonyms. Blackstone agrees with Aquinas that law must be promulgated. He says this means, among other things, that it must be published in a most public and perspicuous manner so that those governed by it can know it. Put a note there, you're going to come back to later this semester. An American jurist by the name of Lon Fuller, who's going to make a big deal out of this idea that the law must be prescribed. And what this means, among other things, is that it must be published in a way that people can know what the law requires of them. And it must be prescribed before the fact, ex ante, before the act that it prohibits. It is not in accordance with law for the sovereign to punish you for something that wasn't proscribed by a prescription of law before you did the act. One of the provisions of our Constitution of the United States, which embodies this principle, which we'll study in a couple of weeks, is the ex post facto clause. The ex post facto clause, which prohibits both state governments and the federal government, the national government, from enacting laws to punish people after the fact, after they've already done something for doing that thing, to make something illegal after it's already been done. 4, by the supreme power in a state. Rules, Blackstone says, come from a supreme power. But who exactly counts as the supreme power is a slightly complicated question for Blackstone. Not so for some of his English disciples, as we'll see very soon. But for Blackstone, it's a slightly complicated question because Blackstone conceives of two supreme powers. One supreme power over the world in general, who is God, and one over England in particular. And who is the supreme power over England? Any guesses? That's right, the sovereign is the supreme power, but who's the sovereign in England?
The king.
Not the king.
Queen.
Not the queen. Parliament is sovereign in England, says Blackstone. Parliament is the supreme power. And this is definitively the case ever since the English Revolution. Whatever doubt there may have been at the time of Elizabeth I, or James I, or Charles I, ever since Charles I lost his head, there's been no doubt in English law that Parliament is sovereign. Blackstone explains this in jurisprudential terms. He says the ultimate act of sovereignty is to make rules, general rules, governing the whole of society. And who does that? Parliament does that. The act of legislating is the ultimate sovereign act. Parliament, then, the legislature, is the ultimate act of authority exercised by persons over other persons in society, and must only be done by the supreme sovereign of the state. So in Blackstone's conception, Parliament is supreme over everything in the society, over customary law, over the courts, even over the king himself or the queen herself. However, even in the state, Parliament is not supreme over the law of God. And this creates complications, as we will see. Fifth, and finally, commanding what is right and prohibiting what is wrong. The most important thing to understand about common law adjudication is that the common law only aspires to provide remedies and sanctions for wrongs. Unlike administrative law, unlike constitutional law, the common law does not set out to socially engineer society, to bring about some ideal state in society. It's not totalizing in that way. The common law is all about remedying and sanctioning legal wrongs. And so the common law is divided in Blackstone's commentaries. The 4 volumes are divided, 2 volumes about the rights of the law, and 2 volumes about the wrongs of the law. And notice the sense of rights and the sense of wrongs. The job of human law, the job of what Blackstone calls municipal law, is to draw the boundary between what is right and what is wrong, what is to be done and what is not to be done. So notice that in the common law, a right is not an entitlement, as many people think of it today. In common laws, it's not something I expect society or government or my neighbors to give me. That's not what a right is in common law. A right is a reason for action. In fact, it is a rule of action. It directs me to act or refrain from acting in a particular way. So the law of battery, for example, secures your right not to be punched in the face, which tells me that I must not punch you in the face. Now what happens if I punch you in the face? I have committed a wrong, specifically the wrong of battery. So wrong and right are just opposites. What a right is that thing that I take away from you when I wrong you, or that thing that I infringe when I commit some wrong against you. Wrongs are classified as either private wrongs or public wrongs, depending on who holds the right. So a private right, say a contract between you and me, that I infringe, results in a private wrong. I was wondering who this was. I like your car better than mine.
You wouldn't want my car.
A public wrong is a deprivation of a right that belongs to the people as a whole. We call those crimes. The difference between torts and crimes, as we call them today, torts is the law of private wrongs, which are deprivations of particular private rights. Crimes, the law of crimes, criminal law, is the law of public wrongs, which is when I infringe a right that belongs to the people as a whole. The common law provides remedies for private wrongs and sanctions for public wrongs. Now this gets complicated when you'll get into punitive damages and other different complications. But it's a little bit oversimplification. But in general, the common law provides remedies for private wrongs and sanctions for public wrongs. That's the basic structure of the common law. If you want to know the whole of the common law, you want to talk about the rights, private rights and public rights. And then you look at the various wrongs which constitute infringements of those rights, the remedies that the common law provides for deprivation of private rights, and the sanctions it provides for the deprivation of public rights. Okay. Are we all clear on Blackstone's basic idea of what law is? Any questions about that? Okay, if that's what a law is, which of these is a law in the sense that Blackstone means? 2 plus 2 equals 4. Is it a law?
According to Blackstone?
According to Blackstone. Is it a law in the sense in which he's using that term in the beginning of his commentaries? That is a rule of municipal conduct. No. It is a law in a more general descriptive sense, right? But in the terms that he means law, is not a rule of municipal conduct. What about a body at rest tends to stay at rest, a body in motion tends to stay in motion? Newton's first law of motion. Is it a law? It's a law in this descriptive, scientific, theoretical sense, but that's not the sense that Blackstone's talking about. He's talking about a rule of action, a rule of conduct, distinguishing between right and wrong. What about you shall not murder? Exodus 20:13. That's God's law. Is that a municipal law? Not by itself. Again, we'll see a complication of this very soon. But by itself, God's command is not, by itself, a rule of civil or municipal conduct. What about Alabama Code section 13A-6-2C? Murder is a felony provided that the punishment for murder or any offense committed under aggravated circumstances by a person 18 years of age or older, as provided by Article 2 of Chapter 5 of this title, is death or life imprisonment without parole, which punishment shall be determined and fixed as provided by Article 2 of Chapter 5 of this title or any amendments thereto. Is that a law?
Yes.
What makes it a law? Is it a rule of action?
Yes.
Whose action is it governing?
Society.
The common man.
I have a grudge against my neighbor. He keeps cutting his grass over the property line. He's cutting it too short and my grass is dying. I'm really miffed. I want to kill him. I'm trying to decide whether it's lawful to kill him. I'm going to go pull the Alabama Code off the shelf and try to figure out which act would count as a Class A felony and which... Is that what I'm going to do? Who's going to pull the code off the shelf, and when are they going to do it? After I've killed the guy, the prosecutor is going to pull the code off the shelf, the defense attorney is going to pull the code off the shelf for the purpose of advising whom? It's a little late to advise me. I've already done it. A judge. Is this, from the perspective of the judge, is this a law?
I would say so.
It's not a law, it's a definition.
How does Blackstone define law?
He says it's not a judgment, it's a rule of action, so
Is this a judgment?
It's a regulation.
that looks like a judgment.
Looks like a regulation.
Murder. Murder looks like a term. Yeah. Is, looks like we're about to get a definition, a Class A felony. If that's correctly defined, are all acts of murder Class A felonies? Murder is a Class A felony.
Yes.
Is that a general proposition?
Yes.
Does it cover all acts that we can define as murder? Assuming we know what murder is. If we know what murder is, are they all Class A felonies? Yes? Does it cover all acts of murder then?
Yes.
Yes? Does it tell the judge how to act when he has a murderer standing in front of him or her? Yes, it says, punish the person by either death or life imprisonment, following the procedures set out in this other provision of law. Does that satisfy Blackstone's definition of law? Yep, that's a law. That provision of the Alabama Code is in fact a law. How about this? This is from Smith versus State, 11 Southern 2nd 466, Alabama Appeals 1942. Malice is an essential element of murder in the second degree. If there is no malice, there cannot be a conviction for murder in the second degree. Is that a law?
I think it's an element.
It is now.
Explanation.
Is it a rule?
Yes.
We have a term, malice. We're told that malice is an essential element, meaning without malice there is no murder. So it's a condition. A condition for what? What can't you do if there's no malice? Convict. Whose job is it to convict someone of a crime? A jury. From the perspective of the jury, is this a rule of action? Yes? Contains general propositions? Yeah? Is it a rule of civil conduct? Does it apply to the jury as jurors? Yep. Is it prescribed? Yep. Prescribed by the Alabama Appeals Court, which is a superior sovereign to the trial court. Yeah? Supreme power in a state, we'll come back to that one. Commanding what is right and prohibiting what is wrong. Would it be wrong, according to this definition of what counts as murder, for a jury to convict someone of murder where there was no evidence of malice? Seems like a law. All right? So we have a law here, yeah? Okay. Blackstone then explains, on pages 234 and following, that the law goes about this business of distinguishing between right and wrong, defining rights and prohibiting wrongs, in 4 stages. There are 4 stages to the operation of common law as it goes about dealing with right, defining and then dealing with rights and wrongs. The first is the declaratory stage, the declaration of that which is right and wrong. That's the first stage. The second stage is the directory stage. That is a direction to observe rights and to abstain from the commission of wrongs. The third stage is the remedial stage, where the law provides some remedy for private wrongs already committed. And then the fourth stage is the sanction stage, or the vindicatory stage, he sometimes calls it. This is where the law provides a sanction for commission of a public wrong. And here's where things get complicated. Because the declaratory stage begins with a lot of unwritten law. That is, law that is not written down by Parliament and has not yet been spoken by any jurist. And this unwritten law includes, among other things, natural rights and duties, such as the duty not to commit murder, the duty not to commit battery, and customary rules. Customary rights and duties and rules, such as the right to jury trial, the right to bear arms. Blackstone says the declaratory aspect of law then has to begin with certain natural rights and duties and customary rights which are already settled. There are certain rights and duties which are settled before they are declared by a legislature or a court. But most matters, Blackstone says, are what Aristotle calls matters of indifference, or what Aquinas called matters of determination, where there's some freedom to resolve these questions in different ways. Reasonable minds can disagree. That's the declaratory stage. The directory stage is when Parliament gets involved and promulgates general rules, general commands. Don't steal from your neighbor. The remedial stage is when a judge or Parliament says, if you do take from your neighbor, if you convert your neighbor's property and commit a private wrong, this will be the remedy. If you steal from your neighbor and commit a public wrong, this will be the sanction. We're going to come back to this 4 stages of development next class. Is that right? Yes, next class. And we'll spend a good bit of time on the first part, the declaratory. So we're just going to bracket this for now and come back to it. Next, I want to talk, though, about 4 different sources in Blackstone's account. Because law must be prescribed by the supreme power in a state, you might think it is easy to identify law by looking at its source. But remember that Blackstone takes it for granted that the supreme power over civil law, Parliament, is inferior to the supreme power over all law, that is, God. And God, Blackstone explains, does not rule directly. He gives us reason to declare and direct ourselves. That is Blackstone's understanding of what he calls liberty. Liberty in the common law tradition is not freedom to do whatever we want. It's freedom to use reason to make our laws. Nor is liberty the freedom to make the rules over with each generation. Each generation doesn't make its laws from scratch. Reason directs us to 4 sources of law made by those who came before us. And they are these: reason, custom, legislation, and precedent. Blackstone's going to break down these 4 sources of law that our reason can access and employ as we resolve our practical problems. Starting with reason. Municipal law, he says, is made by humans for humans. And Blackstone affirms the claim of earlier jurists that what makes humans unique is the capacity to reason. So like St. Paul and Aquinas, Blackstone claims that reason and revelation are the 2 foundations of law. He says on page 227, upon these 2 foundations, the law of nature and the law of revelation depend all human laws. But, he continues, laws in their more confined sense, and in which, this is back on 227, it is our present business to consider them denote the rules, not of action in general, but of human action or conduct. That is, the precepts by which man, the noblest of all sublunary beings, a creature endowed with both reason and free will, echoes of Cicero and Aristotle there, is commanded to make use of those faculties in the general regulation of his behavior. So like Moses, St. Paul, and Aquinas, Blackstone thinks that God gives divine and natural law to human beings out of his wisdom for our good. As rational beings, humans can thus participate in reasoning from first principles to correct conclusions about what law requires. However, notice an important difference between Blackstone's conception of those first principles and Aquinas' conception. What was Aquinas' description of the first principle of practical reason? Who remembers? How did he state the first principle, the first self-evident principle of natural law?
That a man should pursue his own truth and sinful happiness.
Did I misspoke? Did I misspeak? I meant Aquinas.
Oh, okay.
How did Aquinas?
Good is to be done, evil is to be avoided.
That's Aquinas. Aquinas says, first principle of natural law is that good is to be done, evil is to be avoided. Blackstone says, by contrast, by comparison, you just read it for us.
That man should pursue his own true and substantial happiness.
Blackstone says the first principle of practical reason, or the first principle of natural law, is that man should pursue his own true and substantial happiness. Now, true and substantial here is doing a lot of work, which contemporary readers are tempted to overlook. Happiness here does not mean pleasure and the absence of pain. We'll get to a student of Blackstone in a couple classes who takes happiness to mean pleasure in the absence of pain. That is satisfying my desires or my wants or my appetites. That's not what Blackstone's saying here. Blackstone is endorsing Aristotle's conception of happiness, Socrates and Plato's conception of happiness, as a life well lived. True and substantial happiness is if I look back at the end of my life, over the whole of my life, has it been lived in such a way that I am happy with the way that my life has gone? That's my true and substantial happiness. And the first principle of natural law, Blackstone says, is that human beings should do what leads to that. Notice there's a difference here. For Aquinas, good is universal. It is objective. It is out there beyond my desires, my preferences, my own particular virtues. Good is good for everybody, whether or not I choose to ratify it as good. I might prefer evil, but in that case, I'm acting unjustly. Good is still good, whether or not I choose to believe that it's good. For Blackstone, the principles of natural law, the first principles of practical reason, are built into our own preferences, our own actions, our own dispositions. So the presumption for Blackstone is not in favor of a general conception of the good. The presumption for Blackstone is in favor of an individual conception of the good. We'll see some important limitations on this. But for Blackstone, the basic presumption of the law is a presumption in favor of liberty under law. What's happened in the roughly 5 centuries between Aquinas and Blackstone is something called liberalism, the arrival of this idea called liberalism, the idea that the point of law is generally to produce and secure liberty. Now, this raises a number of questions. Blackstone still thinks that it is the office of reason to pursue happiness. So he says the office of reason is to discover what the law of nature directs in every circumstance of life by considering what method will tend to most effectually to our own substantial happiness. This is another important difference between Blackstone and Aquinas. Remember, Aquinas thinks that we can use our reason both to determine what is good and to determine what's the best way to get those goods for everybody, the common good. For Blackstone, the office of reason is instrumental. I'm after my true and substantial happiness, my life well lived. Reason is going to get me the most effective means to achieve my goal. So we might say Blackstone thinks that we naturally choose good ends. We only need reason to help us choose the best means. For Aquinas, remember, we can use our reason critically to evaluate both means and ends. And sometimes people choose evil ends. Okay, that's reason. Next, let's talk about custom and legislation. There are two parts of English law, Blackstone tells you. Lex non scripta, unwritten law, and lex scripta, written law. There's a lot here, but I want to focus on a couple of different things. First of all, if the unwritten law, the customary law of England, is unwritten, how do we know it? How do we identify it? How do we know it when we see it? Well, Blackstone gives you a standard test for determining when a custom is a customary law, when it is a rule of action that obligates you. And the test is this: we can't remember a time when we didn't do it this way. In his language, the goodness of a custom depends upon its having been used time out of mind, or in the solemnity of our legal phrase, time whereof the memory of man runneth not to the contrary. You're going to become familiar with that phrase in your common law courses. You're going to see it over and over and over again. The test for the validity of a custom, it has other elements, but this is the most important element, that it has been a custom from a time when the memory of man runneth not to the contrary. We can't remember a time when we didn't use jury trials to resolve our private complaints, causes of action, and to render verdicts of guilt or innocence. Can't remember a time when we did it any other way. It goes all the way back to before King Alfred the Great. And so that's a good custom. It's a good custom. It's a valid customary law that criminal trials should be made to a jury if the defendant chooses to invoke his or her jury trial right. Now, a tension that you may have noticed already is this. Remember, Blackstone told us that a law is prescribed by the supreme power in a state. How then do we explain this idea that custom is law? The custom doesn't come from the crown or from Parliament. It's law not because Parliament enacted it, not because the king or queen ordered it, but because we have always done it this way. So how does Blackstone explain customary law as law? Who prescribed it?
Or people with supreme power.
The people prescribed it, Blackstone says. And he says this is evidence of English common law's presumption in favor of liberty. That if the people were not at liberty, then they would not have the freedom to make their own customary law. And it's evidence of the goodness of a custom that the people adopted it in the exercise of their liberty when they could have done otherwise. Notice also the difference between general customs and particular customs. You'll find as you go through your legal studies, there are customs of the general common law, which are customary law everywhere. In the English common law tradition, the jury trial is one of those. And then there are customs that are particular to particular communities or particular states or particular provinces. The customary right to roam in Scotland. How many of you have visited Scotland? You have to ask permission before walking across a croft? Nope. Walk wherever you like.
Just close it behind you.
Just close it behind you. That's right. The customary right to roam in Scotland. The right to hunt on private land that's not posted in states like South Carolina and Maine is a particular customary Right. It's not the rule everywhere. It's a particular custom in that particular location. Okay, so that's customary law, or unwritten law. The next thing to note is statutory law, the lex scripta. What's the purpose of having statutes, according to Blackstone? What's the purpose of a statute?
So people can know what law they have to follow.
Law has to be prescribed. People got to know, okay? So one purpose of a statute can simply be to declare. Call it a declaratory statute. That's one kind of statute, Blackstone says, right? People need to know what the rules are. If there's some ambiguity, if there's some doubt, for example, whether the customary right to roam applies in Wales as it does in Scotland, Parliament should declare it and tell us, right? That's a declaratory statute. There's a second proper purpose for statutes, however, which is what?
Is that to provide sanctions if it's broken?
Well, yeah. So there could be some something missing in the law, right? Blackstone says there might be some defect in the law which Parliament has to fix. For example, there might be a lack of remedies or sanctions in the case of breach. Or it might be that it's just a bad rule and it needs to be changed. So he says, beginning in the bottom of page 249, going to the top of page 250, statutes are either declaratory of the common law or remedial of some defects therein. It's going to be an important distinction for understanding the role of legislation in the common law. If you're looking at any particular statute, it could be doing one of two things. It could either just be declaring what the common law already is. You can have a statute, for example, which is declaratory of the right to roam in Scotland. Parliament hereby declares that the ancient right to roam across crofts in Scotland shall be secure in the law, right? Or remedial of some defects therein. So he says declaratory, where the old custom of the kingdom has almost fallen into disuse or become disputable, in which case the Parliament is thought proper in perpetuum rei testimonium, and for avoiding all doubts and difficulties to declare what the common law is and ever hath been. And he gives examples, the statute of treasons, for example. Just telling you, these acts are treason, in case there's any doubt. Remedial statutes are different. These are statutes which are made to supply such defects and abridge such superfluities in the common law as arise either from the general imperfection of all human laws, from change of time and circumstance, from the mistakes and unadvised determinations of unlearned judges, or from any other cause whatsoever. And this being done either by enlarging the common law where it is too narrow and circumscribed, or by restraining it where it is too lax and luxuriant. The point here is that even a remedial statute only changes the particular provision of law that the statute sets out to change. So the legislature then, the Parliament, doesn't create law. It either declares the law and so clarifies it, or it changes the law in some particular respect, but only in that respect. That's the common law conception. Legislatures do not make law. They do not create law. They either declare law or they change it in some respect. Still less, Blackstone says, do judges make law. If you hear nothing else I say this class, hear this. Judicial precedents are not laws. Judicial decisions are not laws. The common law is not judge-made law. We're going to meet someone later this semester, an American jurist, who's going to make that claim. But in the original understanding, the common law is not made by judges. Judges are merely declaring what the law already is and then applying it to particular cases to render judgments. So their precedents, their decisions which become precedents governing later cases, are evidence of what the law is. They are not the law itself. That's the common law understanding. Common law judges do not make or create laws. They declare what the common law is, give its specific application in their judgments. If the relevant rule comes from custom, from ancient custom, the judge is going to first find out what the custom is, state it as accurately as possible, and then apply the test for a valid legal custom. Is it so ancient that the memory of man runneth not to the contrary? If the relevant law is a statute, an act of parliament, the judge is going to look at the text and interpret the text to figure out what parliament intended. And then later judges are going to refer to that legal interpretation as evidence of what the law is. Okay, any questions about any of that before we take a look at cases? Yes?
So there's never a situation, in terms of what you said, of where a judge in the Supreme Court ever makes a law, they just declare what the law already is.
The understanding of the common law jurist, which was universally agreed right up until the day before yesterday, was judges do not make law. The law does not come from judges. Judges do not change the law. That's for Parliament. And both legislatures and judges have the first obligation to declare what the law is. Declaratory aspect. Yeah, very foreign to the idea that many people have today of judicial supremacy. We're going to get to that later in the course.
You said the legislators don't make law either?
They change the law in certain respects in the case of a remedial statute. But any specific, other than the specific proposition of law that they've changed, they leave the common law in place. The general presumption is the ancient customary law is still the law until Parliament or a state legislature says expressly, we intend to get rid of that old rule, that old proposition. Primogeniture, for example.
So,
We're getting rid of it. Until that happens, it's still the law.
so in this situation, the people or the executive branch making the law.
I'm sorry?
So in this situation, the people are like the executive branch making the law.
Executive branch never makes law.
Well, I'm talking about in this situation. I know legislative makes the law.
You're talking about custom? Customary law?
customs, yeah.
Yeah,
People make
customs are laws made by the people.
Yeah.
Yeah, promulgated by the people as they go about solving their practical problems. That's the idea of customary law, yeah. All right, let's talk about Hannah versus Peel.
For more understanding of law, rights, and each other, see my new book, The Age of Selfies, Reasoning About Rights When the Stakes Are Personal. And visit my website, www.adamjmcleod.com.